Hello, everyone. Welcome to Relativity Fest London, the first ever by that name. I think we did a great job of distilling the essence of Relativity Fest and bringing it here. We're delighted to see you all. My name is Constantine Pappas. I am the manager of the Relativity Solutions team for the US. So those of you who know Paul Gordon, I'm sort of the American Paul Gordon, but he is an American, so I'm an even more American Paul Gordon. It's been, I think, 3 years since I was last in London at the Spring Roadshow, and a lot has happened since then as far as analytics adoption and things going on in the world. And it's very interesting for me to be away and come back and sort of get another glimpse as to what's going on in the space here. And I think we're going to have a really great discussion, and we've got some fantastic panelists I'm delighted to introduce to you. So let's go ahead and do that right now. First, we have Sean Doherty. He's an analyst for the Workforce Productivity and Compliance Channel at 451 Research, directing its business and technology coverage of information governance, compliance, and electronic discovery, and software and services to combat fraud. Sean, welcome. Anything to add to that description?
No, thank you. That's very nice. Happy to be here.
Thank you for joining us. Next, we have Richard Legge, manages the e-discovery team at Mishcon de Reya. I got to roll that R. My Mediterranean heritage just comes.
As well, yeah.
What's that now?
It's Richard Legge.
Yeah. Legge. Mais oui. So, and also runs the firm's standalone e-discovery business, Mishcon Discover. He's one of a small number of Relativity certified administrators working with UK law firms and has extensive experience in running complex disclosure exercises for a broad range of clients. Richard, anything to add to that lovely description of you?
No, I think that's wonderful, Constantine. Thank you.
Well, gosh, thanks. I think you wrote it, so it should be good. So lastly, we're already off to a good start, I think. So thank you for your perhaps pity laughter, but I'll take it. Meagan Sauve, did I get it right?
Well done.
Oh, thank God. Now the rest of the day is cake. So she's with our partner Millnet, following a move across the pond from the U.S. So her voice will sound kind of funny like mine, where she most recently worked as a contractor for the U.S. Department of Justice in Washington. One of her main roles there was to advise on relativity analytics best practices. I have to say, and she's also a relativity master, which is kind of a big deal. She was on the screen earlier. So, I mean, let's give credit where it's due. I personally want to thank both Richard and Meagan and their organizations, because they were really a huge part of the pioneering of the relativity-assisted review product. And I think that their evangelism has really gone a long way towards adoption. So thank you very much for that. Yeah. Okay. Let me just switch to my actual notes here. Technology. All right. So our session today is analytics around the globe, and we're going to be talking about some similarities and some differences between the U.S. market and what we're encountering out here in the U.K. and Europe and across the world. And I think that let's just go ahead and move forward here. One of the baselines I'd like to set is what the word analytics actually means, depending on where you are. And it seems like a very trite thing to start out with. It's a very sort of 101, well, what does analytics mean to you? But it's actually extremely important, and I'll tell you why. I was down in Australia late 2015, and I was going to talk to prospects and existing clients, and we were just visiting all day, every day, just like really people that really wanted to hear the analytics story. And I would ask them, are you using analytics? And many of them would say, no. And I would say, why not? Oh, we don't have the right case, or we don't have this, we don't have that. I say, oh, okay. And then I would say, well, do you use email threading? And they would say, oh, yes, on every case. And I'm like, well, then you are using analytics, right? So it really depends. And they weren't thinking of it as analytics usage, but obviously, to our organization, that's absolutely one aspect of analytics. And so some people, for better or worse, associate analytics with strictly like technology-assisted review or a few other sort of conceptual type of analytics, but it's a much broader spectrum than that. So let's go ahead and get started. Sean, let's start with you. What do you think, analytics versus between the two markets?
Well, I guess when you're looking at, we kind of set it up, the difference in definitions of analytics and people's knowledge of analytics. I can't see doing a discovery case today without analytics and doing an investigation just because of the large volume and variety of data that's coming at us in a much more velocity, speed. It's astronomical. For example, I am not a digital native. Shocker, I know. Every morning I get that way. But if you look at, let's say if I was in an IP case, or I should say, I was embroiled in an IP case, what would be involved in defending me as some of my work tools or my resources? I wear two hats. I'm a practitioner as well as a 451 analyst. So you've got two instances of Office 365. You've got my laptop, you've got my PC, you've got my smartphone. You'll have a testing area in AWS, both for storage and compute. You'll have Dropbox, you'll have Box. I'm going to be playing around with botnets on Facebook soon on the business end. So you'll have a lot of data. And that's just an example of someone who's probably an older person in the workforce. That's not even considering some of the new tools that are out there that you're going to have to work with to analyze all this data. And I can't imagine doing it without analytics.
And that's an interesting point. I mean, obviously, when you go to an event hosted by kCura, like immediately we think of relativity analytics, but that's obviously a very small subsection of all the types of analytics tools out there. And a while back we went to a meetup. I don't know, do they have meetups out here where it's just sort of like it's sort of like a more polite flash mob where you go to meet like-minded people in a pub and discuss whatever topic you have in common interest. And there was an analytics one in Chicago when we went, and it was kind of interesting because most of the people there were doing what I would call sort of marketing or transactional analytics, right? Oh, people that, buy big shoes also buy big socks, right? Some were more cynical, like people that have a certain size of clothing need a cardiologist or something like that. And it was very interesting because there weren't a lot of people that were really talking about text analytics, the actual analysis of text. And so sometimes when you talk to someone about analytics, they immediately go to that market analysis thing, and you have to kind of rein them back and say, no, we're talking about something slightly different. What do you have to add, Meagan? You're nodding at me knowingly.
Well, I think that's basically it, is there's this, area of, and Relativity breaks it down really well, there's this area of conceptual analytics where here in the UK there's a, probably healthy dose of skepticism towards, because they need to explain it in order to use it. And then there's all of the attributes type of information about the data, which, as you said, email threading, they just know that exists and they don't really think of that as analytics. Language identification, there are cases you would not be able to get through without, and that's analytics. So it's just a little bit more about your data to pull out.
I feel like it's a little bit of a loaded term that some people are apprehensive just from the word, and if you just said it's this cool tool that does stuff for you, that maybe they wouldn't be so hesitant or alarmed. But the analytics, I mean, it sounds like you need to know something special. Richard, what do you think?
Well, yeah, I think from my perspective, it's just part of a toolkit that we currently have available to us, and I think it's just about how we deploy those tools. And it may, obviously lawyers especially, they're conservative by nature, I think, and they can get a bit scared about any kind of new technology. And that's kind of what my role and what my team's role is about doing that translation, I suppose, between what this machine's doing in the background and then what it can do for you in your case, I think. And that's kind of where we sit and what we're trying to do on a day-to-day basis, I think.
That's really excellent, and we're going to be touching on that a bit more about the internal communication aspects and the roadblocks we encounter towards adoption. And it actually goes in both directions, is what I've seen. But before we do that, I think we've done a good job of sort of establishing what we mean by analytics. So for the purposes of this discussion, we're going to be talking about what we call structured analytics, which is threading, textual near-dupe, language identification. And when we talk about conceptual analytics, that's when we're talking about clustering and we're talking about assisted review, concept search, keyword expansion, similar doc. Fair enough. Just show of hands, how many people have actually used any of these tools? That's an excellent show of hands. Lovely hands. Thank you. I see you're doing good work, soaking them or whatever it is. So anyway, the interesting thing about analytics, and I think Richard hit upon it, is that it's just another tool in your toolbox. I'm doing a session later on called Analytics for Lawyers, and there's going to be a bit of talk about how there's a myth about how you use analytics instead of something else, right? Oh, I could do this, or I could use analytics. But really, it's another tool at your disposal, and analytics are at their most powerful when you're actually integrating them into your existing workflow. Okay, so we set our baseline. And I think the next thing I want to know is, since I've been away for a while, what is changing in this industry out here? What's going on in sort of the local markets that's making analytics more appealing? Meagan, you want to kick it off this time?
Sure. We've had a big interest in a push into tar.
Yeah.
So previously, there were a lot of cases where, they would consider it, but ultimately drop it. Now it's coming up, repeatedly. That's the first question. Oh, could we use tar in this case?
And where are those requests coming from? Like, are they coming from the lawyers? Are they coming from the technologists, or somewhere in between?
Well, we generally are working with the case teams.
Yeah.
So it would be a case team driven, or it would be the end client that the law firm represents, who, well, let's just say it, they may not, when they see the budget requires X number of hours of review time,
Yeah, sure.
they will start to suggest it. But it has become slightly more broadly accepted. So we're seeing a little bit more openness to potentially using it and helping that drive down the cost. Obviously, volumes are going up. They're always going to go up.
So big data is a catalyst.
Big data is a catalyst.
Any other catalysts that you're recognizing?
I think that there's a little bit of shift in terms of the way we consider our disclosure obligations here. And this is specifically the UK. So
Yeah.
you have a menu of disclosure options, right? A lot of times you're trying to narrow down the data during the collection phase. As you have more complex systems at your companies, you have more phones, you have more whichever, that becomes less something that you're able to do.
Yeah.
So we still have the reasonable and proportionate rule in the UK, where you want to narrow it down, and you want to narrow it down quickly to get to your disclosure set or to get to your review set. So that's part of it. We're going to be collecting more data no matter what we do.
Yeah, I should actually advance the slide, I think. Richard, I threatened right before the session to talk about our very first meeting when I came out to London first about five years ago. And it was very telling to me because one of the catalysts, I think, in the industry, and every market has got their own sort of incestuous nature, that everyone knows each other. Everybody sort of is watching each other. And I came to visit Richard, like I said, about 5 years ago, and we started talking about things. And one of the first questions he said was, who else is using it in the UK, And there's a little bit of like, I don't want to be the first, and there's something comforting about knowing that like your peers are also embracing this technology, and it's becoming sort of, common in the industry. And so I think personally, and back me up or agree or disagree with me, but I think that once you reach a sort of a critical mass of usage, then it actually kind of spikes, because everyone kind of recognizes, okay, this is a thing now. Richard, do you have anything to add to that? Do you remember that meeting at all?
Yeah, I do.
I had shorter hair.
Personally, I think over the last 2 years, it's just been quite a big rise actually in the use of any kind of, or especially in law firms, about using technology to do various things. We don't seem to go a week at the moment where we don't see some law firm who's adopted some technology in their practice to help them deliver legal services. We see things like Raven and kCura to do with content extraction from documents, all the way through to Slaughters, I think, have made an investment in an AI company recently. And I think all of this kind of awareness, it kind of feeds into a law firm's competitive spirit, in the sense that if they're doing it, we want to be doing it, because if they can offer a client something more, a better solution than we've got, then we need to be doing that as well. And it's kind of like you're saying, it's kind of creating a mothball effect of law firms kind of getting on board and kind of getting to grips with the technology.
I think that's fascinating. This came up during our one of our planning calls, that the competitive nature of lawyers is one of the driving factors of adoption, and this is the idea that you have sort of this extra weapon in your arsenal that will help you, vanquish your foe, as it were. And as quaint as it sounds, I think there's like a lot of legitimacy to it.
No, I agree. I mean, I think especially where I work at Mishcon, our lawyers are extremely competitive, I think.
Yeah.
If you can offer them something which can allow them to kind of get an upper hand or find their key documents more quickly, they're going to take it, because it's something that the other side might not be doing. And all it allows you to do, it allows you to find those documents more quickly. And what that ultimately allows you to do, obviously, is understand your case and start devising a strategy for your case to ultimately, obviously, give a better outcome for your client. And I think all those kind of things lawyers get, and that's why it becomes much more easy sell, I think, internally, I think.
And as between the U.S. and the U.K., which do you think is more adversarial? I think everyone wants to claim that.
Well, on the call, there was a bit of... I personally find it's very quite adversarial here. I mean, we're dealing with a case at the moment where we're just about to hit probably our 100th round of disclosure. So,
wow,
the parties' views
nice.
on reasonableness and proportionality are obviously different. So, it's quite a contentious area, I think.
Yeah, in the States we have the Sedona Conference. I don't know if you're familiar with that organization, and they actually have a document or a doctrine called the Cooperation Proclamation. And I remember talking to George Sosha about it a while back, saying that there was something a little bit ironic about proclaiming that people will cooperate. There seems a little cognitive dissonance in the title, but but we also, it was a good discussion, and he for those who don't know, George Sosha, I'm just name dropping to make myself seem more important than I am. I'm not at all. But he's one of the co-authors of the EDRM, right, the reference model. And so he was saying that old habits die hard. We can say that everyone wants to be more cooperative, more conciliatory, but still there is ingrained into the lawyer psyche and blood this need to conquer. And it drives the industry.
Sure.
You're agreeing?
Well, on both sides of the pond, you have the adversarial nature. So, and to Richard's point, when you're talking about speed of response, that's all the competitiveness. But also, although we're getting much more volume and much more variety and more complex data, the courts are not giving us more time to litigate our cases. So that speed of response is very important, and understanding your case, early case assessment is key. And to get a handle on your data even before the 26F conference in the U.S. Is necessary.
One of the other things that we have in the States, and I want to see what the difference is here, is I guess we call it the e-discovery or technology bubble for e-discovery or e-disclosure in the U.S. And it's this idea that, I'd say between 5 and 10 or 15% of the industry is actually very savvy with technology and understands how it works and utilizes it regularly. And then the other, let's say 80% of the industry is still very much into paper and more manual methods, and they think DT search is magic and that sort of thing, right? And so, and it can be challenging if you are not symmetrical in a litigation where one side is in the bubble and one side is outside of the bubble, and how do you find that common language to discuss and negotiate and arrive at decisions in order to move the case forward? And I was curious. I mean, what is that like over here? Is there a similar effect? Is it around the same percentage? Is it in scale? Meagan, what do you think?
I think it's a slightly different percentage.
Okay.
I think there's a little bit faster uptake in the US, but once it's bedded in the UK, then it's accepted. So I think that we have a slightly different skewed percentage. So you'll have maybe as Millnet grow, first year here we had maybe 5 to 10% using email threading, and then boom, up to 50%. So it kind of skews based on acceptance, less so than fear of technology. But I do think that the communication back and forth between the two sides There are cases where analytics would be perfect for the case, but going into case management, they aren't going to win on being able to use it for that because, the judge hasn't been primed for it, the other side doesn't trust it, so they're going in with keywords, and that's just a concession that you make. So sometimes they use it internally, but it's not, the
Interesting.
way that it goes. But,
Yeah.
Do you agree?
yeah.
Well, I think we definitely see quite a big spectrum, I suppose, of adoption. And obviously at Mishcon we get to work with, well, we're obviously opposing to Magic Circle all the way down to very, very small firms, actually. So definitely towards the larger end of the spectrum, we're seeing more proposals come through around the use of tar. And at the lower end, nothing at the moment. I mean, even at the higher end, I think it's still much lower than, obviously we think, based by the number of hands that said they're using it, we still don't see an awful lot. In terms of proposals, but like Meagan was saying, that's not to say that you're not internally using it. You may have said you're going to do your keyword search and run a linear review, but in the background, obviously, you might be doing something completely different that still fulfills your obligations.
Yeah.
And then when you go over with the client something universal like cost, and that speed of being able to get your handle on the data at a reduced cost using analytics, that speaks volumes. So.
Yeah, it's interesting because the people that balk at cost, I often find they do so because they don't understand the value, right? And cost and value in any sort of industry with any feature are very much conjoined. And so once you understand that you're going to find things quicker or perhaps find things that you would have missed otherwise, the value becomes more readily apparent. And what sort of conversations do you have with sort of decision makers that sort of impresses on them the value to justify the cost? Richard, why don't you start us off?
So what we've done at Mishcon is we've been doing, I don't know how many we've done, quite a few, probably like 10 or so predictive coding projects, and before prior we were doing it just through agreement with the parties. So now we have a number of lawyers in the business who've been on TAR projects, and I think we have there now are kind of champions to some extent. So when we have a new case that comes in, we can then get that lawyer to come along with us. Because I think sometimes there's a lot more value or some much more compelling argument, I think, when you have a lawyer talking to a lawyer about a case that they've done and what they achieved on that case, rather than a lawyer talking to someone in the tech arena, basically. So that's kind of how we've done it in Mishcon, to kind of help the kind of people get over that kind of hurdle, I suppose, of how the technology works.
Anything to add?
It's very similar. We're in a service provider, so
Sure.
it's similar to that. We have different clients that are in different parts along the path, but they'll submit a budget, and you go through those same steps. If you had this many reviewers, you have this many documents, it's going to take you this long, it'll cost this much, and then they're like, that's not the budget we submitted. Well, that's what your keywords brought back. So then you can kind of wade people in, but the next time around, if they're a repeat customer, they're like, do that thing you did the last time. Do that, do that again. Okay, we'll do that. So, as you get repeat customers and familiarity, it becomes less of a cost question than this is the right thing to do.
Interesting. So at the top of the session, I mentioned that I've witnessed sort of the resistance going in both directions. So what I see is sometimes there's a member of the case team, the lit support team, that's really interested to move things along more expediently, and so they suggest using analytics, and then there's a decision maker on the legal side, on the lawyer side, that says too expensive, or I don't understand this. Those are the two, right? I don't know how this works, or I don't want to pay for it, right? I think the two main reasons, and so there's pushback in that direction. But occasionally it goes in the other direction, that you have an attorney, a lawyer. I have to be careful. I want to say the word attorney. I'm going to go on a whole tirade in my workshop later about that. So stay tuned. But
I'll be there.
so you have a lawyer that says, I was reading about a technology assisted review. This sounds fascinating. Sometimes lawyers geek out like the rest of us. Andrew says, they think like people, but sometimes they think like technical people too. And they go to their case team and they say, why don't we try this? We could save a lot of money. We could do this. And sometimes it's the lit support person says, I don't know. Maybe they don't understand enough about it. They don't want to set it up. They think it's going to be a lot of work to get everything moving, or it's just outside their comfort zone, or some other reason, right? And so this is one of the things that I've witnessed over the years that we're trying to address from both angles. And is one more prevalent in the UK than the other, would you say? Do you think that the lawyers are more into it, or are the case team, the lit support, more into it?
I think after Pyro and those kind of cases, they are. It's, the use of technology is now something that is brought into those discussions. I think at the start, they are questioning at least about how they might do something differently, I suppose, as opposed to the whole, keywords and linear review. I think it's at least part of that discussion at the outset. And I think obviously having people in house, you can really and who've got experience, I think, in doing those projects, that really helps them kind of get over any kind of hurdle, I suppose.
I think one of the big keys is the visualizations as well.
Yeah.
I mean, when you can actually take a concept like clustering and filtering, people understand those quite readily, but then you turn on prioritization with those visual packages. It can be a very good description of what is to come.
Lawyers like shiny things, basically.
Everyone likes shiny things.
That's true. I'm very distracted by them myself. What do you think? Anything else?
Well, as a lit support provider, obviously we would hope we wouldn't have anyone that's like, oh, that's too difficult to set up, because but so we'll always do that. But the stumbling block we have isn't so much that this is going to be too difficult to deploy. It's that we've had cases that come to us where they're like, we're going to do tar, and all of your data is audio, so that won't happen. That's just so. That's
Stay
an extreme.
tuned. I'm not sure that's true, but
but that's an extreme. But there are things where you do. We've put this into our EDQ. We've talked it over, and we've decided we'd like to do this. And you have to take a look and say, that is an option. This would work better for you. So it's just knowing what would work for the case. And
I'm having audio file review flashbacks now. There is a medical parts case I worked on many years ago. I had to listen to audio files, and it was like call desk stuff. This is completely unrelated to analytics, but I'm going to tell the story anyways. So just, and you had to listen through. You didn't know when they were going to come back. They put people on hold. It was like kind of an insurance thing. So they'd call in and say my doctor says I need this whatever prosthetic or whatever, and then they put them on hold, and they would always play Ein Klein Nacht music over and over and over again for weeks and weeks. I just heard it in my sleep, and now I can't. I just hear da 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 da. Anyways, it drives me nuts. So thank you for bringing that memory back. It's a waking nightmare. I think I'd like to open it up to the room. If anybody wants to step forward, I think we have a mic runner. They want to talk about any resistance to adoptions, conversations they had, and how and if the obstacle was overcome. Anyone? I saw a lot of hands of usage, so I don't believe that none of you had any.
There's no problems out there, I guess.
Any conflict whatsoever. No? Oh, here we go. I knew that if I shamed you enough. We got a mic coming. Thank
Hello.
you.
Wow. My name is Renee. I'm not from the UK or the US. I'm actually here on behalf of my office in the Netherlands, PricewaterhouseCoopers. So we're also service providers. I've heard a lot about the hurdles that you're dealing with in the UK or the US. I was just wondering if anyone from the European markets actually have anything to share about the hurdles. But what I heard the most is actually about the lawyer saying that we don't want to buy that because then our will be cut for TARs, etc. So this is actually something that I heard the most, but I'm not very experienced in this area yet. Mm-hmm. I just wanted to hear, how would you answer this question if you are asked?
Yeah,
sure.
Great.
Analytics is actually very good. We have a case running right now that's half in English, half in Russian, for example. When you have two case teams that need to work together, and especially if the data in the Netherlands may be easier, but if we have data in Germany or in Belgium, can't leave until it's cleared, but we still need to have some coordination. What we're doing right now is we're clustering that data together so our English team can kind of understand the Russian data set just because the same documents will kind of cluster together. So when you're working in Europe and you have those challenges, even if you're not doing tar, tar can be a quick way to get them to allow the data to be released if you do need to release it and get over data protection issues. But just allowing teams that aren't speaking the same language, if it's language agnostic, to kind of be able to understand each other's side. And we've used that to kind of understand the two sets of keywords, right? Because the English keywords and the Russian keywords can't just be a direct translation. They may be overly inclusive here. So understanding how these things fit together. We only have so many bilingual speakers, but our English review team is able to understand what's going on in the Russian data set through things like email visualization and cluster visualization. So that might be a good way to get it up.
But sorry, do you mind if I ask a follow-up?
No, not at all.
But do you actually get a question from the clients? For example, they ask you to do a comparative analysis about the cost. Like,
Oh, yeah, in terms of cost, well, we have a different pricing model. So we don't have as much of a barrier cost in terms of the analytics. For something like tar, we do have a bit of a consulting cost associated with it. But that is, similar to your standard costs that you would do on how to scale out your review team, right? Do you need 2 senior people, or can we bring paralegals in? There are metrics out there that will allow you to help scale it out so your attorneys can see the benefit of putting it through analytics, just in terms of email threading, getting rid of non-inclusive data, just organizing your data so the conversations are together, speeds up your review cost, right? So you have one reviewer reviewing chronologically, they'll see an email over here, you might have the 10th reviewer over here that sees the end of that conversation. With analytics, you have the same reviewer seeing the whole conversation. So in terms of cost, it speeds up your review. So take a look at how much they're spending in review hours and see which tools, and I'm sure kCura has some metrics that can help you out and push that across.
We might be able to help you there.
We have some internal from our internal case studies, but I think they have some globally.
Is that helpful?
thank you.
Oh, thank you very much. Oh, great. So you started it rolling now. You're the great facilitator. That's your new nickname.
Adam Foraker, McFarland's. So to answer your question, I think in terms of resistance to adoption and the using of things like technology-assisted review, I certainly have encountered that, and I think that there's 2 reasons. One, some associates and senior solicitors will have used TAR quite early on, and if they haven't quite understood how it is that you're supposed to go about training the sort of predictive coding algorithm, then they're going to get a lot of junk back, and as a result they think, well, it's crap, so we're not going to use it. And then the other one really is, as you say, this sort of not understanding it and therefore not being able to defend it. So one of the ways in which conceptual grouping works, obviously, is through latent semantic analysis. But most senior solicitors wouldn't have a clue what that means. And the time between them using some discovery platform like Relativity can often be 2 or 3 years for them, between projects. So that, and technology moves very fast as well. So all of those things can provide sort of instinctive barrier to using those kind of technology, or that kind of technology.
Do you think that kind of barrier is ephemeral? I mean, when you think back to like other technologies when they were new, everyone wanted to understand how they worked until they sort of said, I really don't care that much, let's just use it. Like OCR. Like OCR was like this amazing thing, and it was terrible. It's better now, but it was terrible back in the day. But now no one really cares how OCR works anymore. I certainly don't understand it. I understand analytics way better than OCR. How do we get to that point where people say, yeah, it's this thing, it works, it's been established, everyone's endorsed it. Is it just usage? Is it just ubiquitous nature of its presence?
To get what you're getting at, I think the lawyer has to really be knowledgeable of the technology and how it works and how it can be applied to the case. And it's really focused on the client's data as well.
Do you think they're focused on that too much? The reason I ask is I remember when I was practicing, it had nothing to do with analytics, but it was a technical case And the partner came in on the first day and he said, look, there's a lot of moving parts to this. Some of it are technical. I don't need you to be able to build a refrigerator. I just need you to be able to spot one, right? So why with analytics is there this sort of almost mania, this obsession to understand the intricacies of something? Is it a defensibility thing? Is it a comfort level thing? Because it seems to be extending beyond what the normal threshold of sort of necessary understanding and preparation would be for an attorney in a lot of cases. Because they kind of have to learn a little bit about their client no matter what they're doing, right? If your client's in medical, they have to learn about medical things. If they're in some other thing, they have to learn about that. So how is this different? Richard?
I mean, I would say, yeah, it's lawyers don't want to get themselves in a position where they go to some CMC and they get challenged by the other side about what they're doing and they can't answer the question. That kind of probably fills them with the worst kind of dread. So I think they do have to know roughly how it works, and we've got various analogies at Mishcon about what it's doing in the background, and I think they generally get comfortable with our description of what it's doing. And it's pretty simple. We just say, if you've got a document and it gets rid of all the junk words and it leaves in the words that have meaning, and it puts documents together which have similar volumes of those meaningful words, basically. To the extent that if we had, all of a company's documents and we threw them up in the air, all the employment contracts would end up here, all the share price agreements would end up here. And once they kind of get that kind of understanding around what the process is doing, I think they feel a lot more comfortable. And they don't need to really understand all the kind of, concept space and all those kind of weird things. They just, as long as they can get over that kind of, that initial thought about how it's working, I think, and they can feel confident talking about it, I think, at one of these CMCs or...
Well, let's tie that. Let's move on then, because I want to talk about your specific analytics experiences in your profile. So, in your mind, which tools are the most accessible to the people you're trying to convince? What do you put in front of them and say, this is what we can do? TAR can be very daunting, right? And then there's a longer sort of workflow cost as far as time expenditure is concerned. So, what's your go-to when you say, let's use analytics? Where do you start? Go ahead, Meagan.
It's email threading. That's
Threading?
the easiest one.
Yeah?
That's, in general, anything with pictures is going to be an easy sell. So visualization, clusters, that's better. But in terms of what they'll pick up and what they'll use most is going to be email threading, and then a lot of times language identification. So that's
And on
easy.
all cases, that's pretty much a standard?
We are pretty much every case. It's as common for us to start the email threading as it is to build a DT search index. We're going to assume that they are going to have keywords. We're going to assume that they are going to want to do this. It's just part of our workflow now.
And that's really interesting, because one of the things in the before times was that we'd see people say I really want to use this analytics stuff. I'm waiting for the right case. I got a big case coming up in 6 months, and we're going to jump all over it. And it's I think people are realizing now, you got 10,000 documents even. Threading them is still providing value, And why not cut your teeth on these smaller ones so you know exactly what you're doing in the bigger cases? There's no reason not to use threading, right? I think we agree. That's kind of sales pitch, forgive me, but this is really more of observational, that I'm seeing lots of people come to this realization, and I naturally I'm delighted. Richard?
I agree with Meagan. I think things like email threading, that's the one thing we probably tell a lawyer about what something's doing in the background, because if they understand how that works in practice, I suppose. And then I'm a big fan of the similar document detection. We quite often get asked, can we find all the versions of this contract or this document? And I think it works really well, because obviously you get your similar documents and then you typically see quite a precipitous drop at the point at which you've found all those documents. It'll go from 90% and suddenly you're down to 73. So at that point there, you can be quite confident that you've pretty much found all the documents in that database.
Show of hands, how many people have used the Find Similar Document feature? So a fair number of hands. It's pretty impressive. I think to me, keyword expansion is sort of the gateway drug, because it's using analytics to find better keywords.
Yeah.
But I think Similar Doc is another one where it's you're just clicking on a document saying bring more like these back, but they don't even have to have a single word in common. It just is able to distill the common concepts between them.
Exactly.
Is that a aha moment for attorneys when they finally get to see that?
That is, it's funny because it goes in cycles. You'll show it to them and they're like, aha, but that right-click analytics menu just goes out of your mind for a while. And then we'll get the question like, oh, I found this contract. Can I find all the rest of the versions? And I'm like, well, yeah, you can right here, right-click while you're right when you're on it. But we're happy to run the search as well, either way. But yeah, I think that's...
No, I think that's true, yeah.
Oftentimes I wonder why we're talking about this, because many of these things should already just be baked in. In other
Yes.
words,
Yeah.
email threading should just be baked in. And I guess my go-to thing would be the clustering and the filtering, the visualization. Put the picture in front of them, understand your data immediately, and then move into just how much of that data is email, and then start the email threading.
Ever have a situation where keyword expansion kind of like resolves something? I've seen lots of cases where, like, because negotiating the keywords between the parties is a very contentious process, right? And oftentimes the end result is perhaps a list of words that is not useful for either party, right? And then you run your searches and nothing comes back, and the other side says, what do you mean nothing comes back? I know you have these documents, and it turns into this whole thing, right? Keyword expansion, is that a way to get around that?
Yeah.
Yeah, I think so, definitely, yeah. I mean, I think we all know, a lot of people in this room probably know how clunky keywords are in terms of finding documents that are relevant in your case, because it's typically a lawyer 4 years down trying to interpret what happened in a company some time ago and what keywords would have been used in that situation. And I think they're a very blunt instrument to solve a problem, basically, whereas keyword expansion or even starting a TAR project based on just the full population of documents you collected is obviously sometimes a more reliable way to go.
We just had one yesterday because it is the agreed keyword, problem. A lot of times we'll agree a list of keywords.
Yeah.
I've had brick agreed as a keyword. Everything in Brick Lane is now in your review set. But we did yesterday an exercise with an attorney who had agreed keywords. They're locked in. They'd been fighting over them for months. They aren't going to go back on the keywords, but now we have too big of a data set. We use keyword expansion on some garbage clusters to find some exclusion terms to propose.
Oh, wow.
Because, yes, you've agreed these keywords, but you've got too many documents to review, so you can add in more keywords that way too. And I don't think most people think about using analytics
In the
for the
negative,
inverse.
as a culling tool.
Mhm.
But I think that's part of the evolution, is that people are really wanting to use analytics earlier in the process, on the left side of the EDRM, before they actually start reviewing, just to whittle down what they need to look at. And I think there's a lot of intelligent ways to do that. Are you seeing any other sort of approaches that you want to discuss? John, you got any thoughts on this?
Could easily move into information governance and look at your preservation requirements and even your document retention requirements. And in that way, I think we're looking at a lot of these analytical tools and even some predictive tools to be able to winnow down enterprise data in a retention schedule and kind of back end the technology before you even get to litigation. So that's my take on it.
Anyone else, Richard?
I mean, I think as well. I mean, I'm sorry, Constantine, but we also at Mishcon we look at other technologies together. I don't think it's a one size fits all. I think there are.
Well, welcome to Other Technologies Fest, everyone.
And they're amazing, really. But there's certain things like communication mapping that we're really interested in, etc. Because you know, as a lawyer, I'm not a lawyer, but a lawyer typically knows at the outset of a case that it's going to be a conversation between Dave and Robert that's probably and in this time frame, which is really important. If you can get some technology that's going to just help you find those documents really quickly and the concepts they're talking about, all those kind of things are kind of I think where we'll get to in the future. Really.
Okay. Now, there's a different philosophy as far as what you actually need to search for and collect between the UK and the US. You don't have to search under every stone is the phrase I hear all the time when talking about the UK market. And I was wondering, how does that sort of difference in disclosure duties feed into analytics adoption? Does it support it? Does it sort of thwart it? Is it a little bit of both? What do you think?
Yeah, I think, as you said, that as it moves further to the left, when we have data same company, reusability of data, you'll be collecting more. So the analytics feature will become more part of your search tool set rather than the collection and harvesting and negotiating what we are and aren't going to search, right? So, you know, just in terms of storage being different. So backup tapes.
Backup
versus,
tapes.
I know.
Are they less important here in the UK?
I mean, it's still a difficult one. I mean, we spend a lot of time arguing or discussing with the other side about what we think is reasonable and proportionate, I suppose. Because obviously those words have different meaning for various people, I think. But I like the practice direction is good in some ways, in a sense it sets out, you know, what dictates a reasonable search around, you know, the likelihood of finding something elsewhere. And sometimes with backup tapes, you know, you are more than likely just to find it in the PST, which you can extract from the live system, etc. But you know, it's generally around the cost. I think they can produce quite a big cost barrier, I think. But I think Meagan was saying in our pre-call about the whole, they are typically a complete set of data, and they potentially are better to use, I suppose.
Yeah.
Well, technology is actually cutting back on the proportionality agreement there, especially when or requirement, especially when you talk about backup tapes.
Exactly.
I mean, dumping the index and the metadata from the tape and understanding what's on that tape very quickly. But even before that, most people understand. I'll go back to the Sedona principles about backup tapes. I mean, it's duplicative. I mean,
Right.
it's something that is a go-to in the event that your main production is in question.
It's always, yeah. But we do get a lot more expansion on that, where you can't really cut down your proportionality on backup tapes if that's the most appropriate thing. You know, if they're saying, oh, these servers have been shut down, but we have the tape, you're going to need analytics because you're going to get a larger volume than being able to search and cherry pick off a small server.
Fair
You
enough.
just are.
But if you're having information governance and you know what your data is, and before you've actually collected that data for particular litigation, then you can actually exclude your backup tapes right off the bat.
Exactly, correct.
So,
I think there's going to be a lot of other sessions that are going to be a little bit more law-centric, legal-centric. We've got David Horrigan sitting in the front row, typing out probably every word I'm saying.
Pretty much.
I look forward to reading what I said later. David, thank you for that. In the early days of assisted review, we used to get lots of calls saying, has this tool been vetted in the courts? And I found myself in the unusual position of apologizing for not being sued, right? And but I wasn't particularly concerned. And Judge Peck is here, and De Silva Moore eventually came along and brightened everyone's day, so thank you, Judge Peck. He's a small-town judge from a city called, formerly known as New Amsterdam. But before that, I really wasn't concerned, and the reason was that the U.S. Department of Justice called me, and they said, we know that you have this technology, and we know that for an organization such as ourselves that doesn't have the resources to review documents, this is desirable. We want people to use this technology. We just don't know the right questions to ask them, so that we want to ensure that they're using it correctly and properly. So how do we get there? And to me, that was the watershed moment where I knew that assisted review was going to be accepted and widely used. And it was because if the government really wanted it, to me that was, I don't know, it was a greater sort of milestone or indicator than a lot of some of the court stuff that came later on, all deference, again, to Judge Peck. So I guess what I'm asking is, are we over-reliant on the courts? Are there other sort of flags or I guess milestones or events that we really should be watching in order to see how the industry is moving? What do you think?
I mean, I think from my view, even before Pyro, we've done a few predictive coding projects. It was just through, you know, coordination and agreement between the parties, and it wasn't, I think as long as you, on the opposing side in those cases, we had sophisticated law firms who probably had their own in-house or sophisticated providers, I suppose. And that just obviously eased the conversation, I think, around the reliability and the defensibility of what you're doing. And, you know, with the TAR and the relativity TAR process, the statistics that are sat there in the background in terms of providing you reports to the opposing party about what you've done and how you've sampled your not relevant document, etc., it's a very defensible position to sit in, and I think, and based on the proportionality argument, it's very hard then for the other side to come back at you and say, no, I want you to review all 100,000 documents in your not relevant population. It's going to cost 100,000 or 200,000 pounds, etc. I mean, it's just not proportionate, basically. So,
Go ahead.
I think that Pyro is helpful, right? It's also kind of given everyone the idea that there might be a magic wand or that your TAR process will always be the same way and you're always going to sample this amount. So while case law is helpful, there are times when you do need to guide it against and say, well, that's not actually going to work for you. So you have a lot more, if you have people that are adopting it internally, just for prioritization, just for quality control, I've found that, and I think that's probably just being a litigation support provider, that we've kind of have firms that are trusting us, you know, more so than necessarily what's going on in the market. But yeah, obviously anytime you have something like Pyro, it's going to be a huge driver for interest.
Well, I think looking at the judiciary, and all deference to Judge Peck, as to driving this model, you have to look at the attorneys and the cases that they're handling, because the judiciary is going to go with whatever the agreed parties have for discovery. It's that agreement, and so I'm with Richard, is that, you know, when you come together and come up with a discovery plan, the judiciary is obviously going to guide you and is going to make sure it's a fair process, but it's going to be that agreement for discovery in the end, and that's the cooperation. And I think that's true on both sides of the pond.
Great. Well, we've got about 10 minutes left, about 8 minutes left, I should say. So I'd like to move forward to your vision for the future. I was on a panel once, and they asked me, and I said something to do with lasers, and I got a chuckle, but it was another pity laugh. But where do you see us going? Richard, go ahead. You're at the end there.
I mean, I think it's an inevitable kind of scenario, I think, in the sense that we are going to be doing predictive coding or running analytics across document sets. You know, it's just inevitable, really. I mean, we can't, with the whole kind of argument that a law firm, obviously, because law firms, you have to understand, they've got a vested interest in doing long linear reviews because on the chargeable hour model. But obviously, any law firm who hasn't kind of made it beyond that, I think they're kind of, you know, they're in a difficult position these days. So I think it will just be inevitable, and I think it will become even more intuitive and more kind of easy for lawyers to understand. And there'll also be other kind of analytic tools that we can do around entity extraction and sentiment analysis, all these kind of additional things that are going to help us understand documents. I mean, the whole world of machine learning, I suppose, is, you know, it's going to get more and more interesting, I think.
I think it just becomes another search tool. You know, we never talk about DT search versus SQL anymore. I think analytics, especially text-based analytics, especially if you have multiple models and you can integrate them, it just becomes as accepted, and it moves more to the left of the EDRM.
I was going to ask that, and maybe Sean, that's part of your answer, is like, do you think that the corporations are going to be just using analytics before anything even happens, when there's even a legal holder, an instance of anticipation of litigation that's already going to be in play?
I'll get to that in 30
Okay, sorry, I
seconds.
took words out.
To follow Meagan here, the analytics we're talking about today, I think will be just all baked into the product tomorrow. And we're talking about newer analytics that are coming on with machine learning and behavioral analysis, things like that will become the new analytics that are going to be questionable later on. And if this doesn't happen, we're going to push the analytics and the predictive analysis into information governance, and we're not even going to have all this data when we go to litigation.
Okay. Well, we have about 6 minutes left. I wanted to leave some time for questions. Does anybody have any questions for our panelists? We've got a mic runner. Over here. Thank you, sir. Just a moment.
Jonathan Flood from Night Owl Discovery, across the smaller pond in Dublin. GDPR is pending, and I'm sure if there's lawyers in the room, they're all sick and tired of talking about it. But how do you feel that the GDPR push towards information governance and compliance is going to affect the use of analytics as you're saying, it's going to push it into the left side of EDRM. And do you think that tide will eventually move towards that space? It's going to be all IG.
I believe so. And I think that's the direction it's going, especially with GDPR. You have to, I guess at the very outset, know what your data is. A lot of the early case analysis tools can actually tell you that information. And then once you have that information, you can act on it, make it actionable. That's going to go into an information governance plan for retention and preservation. So I think that's the direction it's moving, and that's why I've said that, you know, if the litigation and the complexity of the data that's being processed in cases doesn't push this, I think large enterprises with a lot of information governance requirements are going to start to push it, and regulatory requirements are going to push them right over the edge. And GDPR is just one of the instances in regional play for global privacy that's happening all over the world. Japan, Argentina, Brazil, China, Russia. So yes, I think the regulatory schemas in all those areas are going to start pushing the envelope for information governance and more tools to start defensively deleting this data.
Another question? Looking over my glasses, I can't see distance. Anyone? Anyone? Any final words from our panel here about the future?
That gentleman just gave me my.
That was your.
That was my. That was my feature. Thank you.
Are you a shill, sir? Is that your plant? No. Okay. Well, nicely done. I do have one follow-up question. Oh yeah, we got you.
You spoke about the law firms inheritance,
Have you had any success in, or what would be the best way of approaching law firms to try and make them see the light and stop attracting clients? Because over the water in Ireland, my biggest difficulty, my biggest barrier to selling technology to anybody is the lawyers say, well, hang on, if I spend 20 grand on analytics in this gigantic case, that's 20 grand I don't get to build myself. So how do we turn that ship?
There's a partner out in the U.S. They're in D.C. and they said that one of the things they like is what they call the dim sum approach. If you look at some words on a menu, you might not be inclined to order it. But if somebody wheels up a cart and shows you what it is, it may look very appetizing, right? And I actually think that that's really a great way of showing. If you can run threading on a small set of data and say, like, look what you could be doing, this took no effort at all, I think that sort of seeing is believing thing is a huge part of getting towards adoption. Anybody disagree, or do you take that approach?
I think there's that. There are two things, if you're in, no offense to any practicing lawyers if they're in the audience, but the competitive nature of attorneys. If you're saying I'm using it, you are now in a better position if your opponent is, you know, the one that's lagging. In terms of billable hours, even with a good timeline, your attorneys are going to be right up to the deadline reviewing documents anyways, right? I mean, I don't think that analytics is taking anything away from their billable hours, maybe in review, because they will always find something else that they can look a little bit closer at. You're always going to run out of time. So I don't think that it's really a takeaway, except for it's a takeaway if you have like 200 reviewers, you know, or managed review. But in terms of the attorney, it puts them just in a better position in their case. They can address better questions, give better guidance, be more in control. And it also, you don't want to be the person who's saying no when you go into the case management conference. You want to be the person that's already come up with a plan and has integrated it, and let the other side be the one that's on the back foot. So that would be my advice.
I think as well, it's also a case of, it's not always a case of finding the relevant documents. The way I sell it more effectively, I say, is you're going to spend less time looking at not relevant documents. And if you tell a lawyer that, he's going to be able to get rid of all this dross that sits over here, and he can actually just work on strategizing and kind of dealing with the actual issues. I think it's much more compelling, I think, to tell a lawyer that that's what they can do.
If I could also just really quick quote Judge Peck, he says, people can't spell, you know, and that's a great way of showing what you would miss if you're looking for exactly these words, right? And I think that's compelling. Like, look what you would have, this important document would have slipped through your fingers. Well, I think we're just about out of time. Richard, Meagan, Sean, thank you so much. Excellent job. Why don't we give them a round? I clap and I've got the clicker and it'll just be this awkward thing. Some resources, training, documentation, workflow support, that's our team solutions. Technical support is support@kCura.com. Please contact us if you want more information. And you're going to get a short survey. Let us know how we did. But we really appreciate your attendance and participation in this session. And please stop by the demo stations and get your hands dirty. So thanks again.